Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 196, within sight of the magical figure of episode number 200, and I think we're going to achieve it by the end of this year. I want to talk in this episode about a case that I think is very on point, although it is somewhat surprising that the claimant thought it was worth appealing to the Employment Appeal Tribunal on this particular point. So it's the case of Umbar and Michael Garrett Associates Limited and Leicester Theatre Trust Limited. The case, as I say, was an appeal to the Employment Appeal Tribunal against a ruling by an employment tribunal that is made at the case management stage. The Employment Appeal Tribunal initially ruled that there were no arguable grounds for appeal, and so the claimant appealed under Rule 310 and asked for an oral hearing to argue her case that her grounds of appeal disclosed reasonable grounds for bringing an appeal. Now, there were two parts to the appeal. I'm just going to focus on one part, which was that whether or not the hearing was going to be in person or remote. What I'm talking about here, of course, is the final hearing to determine her complaint. So you can see immediately why I thought this was a relevant case to put into the podcast. Factual background is that the claimant is an actress. She was represented by an agent, and through her agent she was taken on in a production of a play which was based on the novel by Alice Walker called The Colour Purple. I remember seeing the film way back when. Anyway, once her engagement was announced, and she was going to be playing, I think, the lead role, once this engagement was announced, another actor pointed out on social media that the claimant herself had, quote, some years before, unquote, published a Facebook post in which she'd made statements which were clearly quite hostile on the topic of homosexuality, and she linked her views to her religious beliefs as a Christian. Once the posting by the claimant became widely known, the agency sacked her, as did the company that had taken her on to play the role. Now, both these relationships, if I can put it that way, were covered by the Equality Act 2010. So she brought a claim arguing she'd been discriminated against on the grounds of her original belief and that she'd suffered unlawful harassment. The respondents argued that the publication of the Facebook posting in 2019 gave rise to widespread concern and upset. And this didn't just affect the claimant, it also affected the other two respondents as well. The second respondent also asserted that the claimant's views were particularly troubling given the positive depiction of a same-sex relationship which lay at the heart of the play. Which does make you wonder if the claimant had read the book or the script before agreeing to appear in the show. Of course, I think in fairness to the claimant, I have to point out we don't know when she posted her Facebook post that gave rise to the trouble, and we don't know if since then the claimant has modified or altered her views on the issue of homosexuality in any way. Anyway, case management hearing took place on 30th April 2020. All three of the parties were represented at it, and there was significant debate as to whether or not the hearing would be in person or whether it would be conducted remotely. It was agreed that there were going to be 7 witnesses between the three parties, and the hearing would require 10 days of tribunal time, which was to include time for the tribunal to determine the issues. So it's clearly going to be a pretty full-on hearing if you've got that number of witnesses, that length of time dealing with these issues. Well, the decision by the Employment Tribunal at the case management stage was that the hearing should be heard in person, notwithstanding the existence of the global pandemic, and the hearing was listed for February 2021. 3 pages of the directions decision considered the various arguments in favour of and against the idea of having a remote hearing, and ultimately the tribunal came down in favour of the hearing being conducted in person at the tribunal and not being conducted remotely. Well, the claimant, for whatever reason, wanted to challenge this ruling by the tribunal judge. The grounds of the appeal appear from the summary given at the Employment Appeal Tribunal stage, to have been somewhat strange. Now, I fully appreciate I'm relying on a summary of those arguments as set out in the EAT judgment. Moreover, it's very clear that the EAT judge was not impressed with the claimant's submissions at all. As evidence for that particular conclusion, I'd point out that before getting to the part of his decision giving the outcome of the appeal, the judge comments that it was, quote, astonishing that an appeal should even have been considered, unquote. And it was clear that he was hugely unimpressed with the arguments being put forward. Well, what were the arguments being put forward, I hear you ask? Well, first, the claimant argued that the tribunal judge was wrong to decline an offer by the organisation supporting the claimant, which is called Christian Concern, to host the platform on which the remote hearing would take place. This was instead of the proposed alternative platforms of Skype for Business and Zoom, which the tribunal was apparently considering. The claimant argued that it was irrelevant or improper consideration for the tribunal judge to point it out that if he'd agreed to the claimant's suggestion, it would have meant treating this case differently from others. It was carving this case out from all the others. More importantly, you think, the judge in the EAT pointed out that although the claimant's offer to help host the hearing had been declined, that wasn't even the basis on which the application to have her tribunal hearing heard remotely had actually been decided. The tribunal, the Employment Tribunal, has said its decision fairly and squarely on the basis that the principle of open justice was better met by having a hearing in person rather than remotely. There's going to be extensive public media interest in the view of the respondents, and frankly 2 minutes online looking at the newspaper coverage of this story will tend to support that view. Well, there'll be 5 days of extensive cross-examination of the claimant. The tribunal, the Employment Tribunal, did not accept the claimant's position that most of the facts are not in dispute. The tribunal considered the respondents had a right to that level of cross-examination, and that the, quote, subtleties of observance of witnesses and the smooth running of the hearing with the right of public and press to attend and observe is particularly important, unquote. Stop. The judge then considered the claimant's argument that there would be delay if the hearing was expected to go ahead in person rather than remotely. This is an odd argument to make, given the main hearing is now set for the 1st of February 2021, and the EAT hearing itself only took place on the 25th of November 2020. So the claimant asserted there would be concerns about the risk of the hearing having to be cancelled because of the COVID pandemic if it was going to be heard in person. This would not apply if it was scheduled to be heard remotely. But the EAT judge pointed out that at all times in-person tribunal hearings have been permitted during the lockdown as a result of authorisation given in the relevant rules and regulations. Furthermore, the judge commented that the Employment Tribunal was right to be wary of allowing one party to host the platform through which public access will be provided, without there having been an agreement to that effect by both parties. Well, summing it up, as if the judge's views weren't clear enough, the EAT concluded this part of the appeal by saying, quote, this is an appeal which is not only pointless, but totally without merit, unquote. Stop. So, I think to adopt an analogy, less the Tigers are the better of the Christians in this particular round, at least. So, well, why did I put the case in the podcast? Well, there are clearly going to be a number of cases dealing with the vexed question of whether or not it's appropriate to have hearings heard remotely, or in person, or as a hybrid case. These issues will not be easy to determine in some cases. Parties wanting extensive cross-examination of the other side's witnesses may fear remote hearings with the lack of safeguards that exist, and the greater difficulty, which was alluded to by the tribunal judge in this case, of studying the subtleties of the witnesses as they're giving evidence. Conversely, a party with health risks may feel that it is prejudicial to their legal position if they're being asked to run a risk to their health by attending an in-person hearing. That would surely amount to pressure on, say, a claimant with health issues to settle their claim before matters get that far. An unscrupulous employer might well be aware of that, and vice versa. If the employer's witnesses, one or more of them, have health issues, an unscrupulous claimant may view that as a pressure point. However, the point that is very clear indeed from the EAT's judgment is that this is a matter of discretion for the tribunal judge. It's difficult to see the basis on which valid grounds for appeal will be likely to come out very often, and the EAT has made it very clear it doesn't want to be distracted by appeals seeking to re-argue matters that are essentially a matter of discretion for the Employment Tribunal judge. Against the background that the tribunal judge had taken 3 pages of the decision to explain why the claim was going to be heard in person rather than remotely, it's clear the tribunal judge had set out to give a very thorough consideration to the claimant's arguments, making a successful appeal all the less likely. Therefore, if you are going to be making submissions to a tribunal judge on the issue of whether the hearing should be in person, hybrid or remote, then it's very important to put your best foot forward to the tribunal judge, because there's probably no second bite of the cherry after that. I think I'm mixing my metaphors there terribly, but you do know what I mean, I trust. Well, anyway, that concludes this podcast. Thank you very much for listening. We'll be back again tomorrow, or maybe the day after. The next episode is the first of 2 podcasts dealing with a review of 2020 and then looking at 2021 and the key cases coming through. So the first podcast up will be with Miriam Bruce, looking back at 2020. And then the follow-up will be with Chris Fisher, looking at cases in 2021 and seeing if he can repeat his feat of being able to predict the outcome of key cases for the 3rd year in a row. So, thank you very much for listening. I hope everyone continues to keep safe and out of harm's way. It only remains for me to confirm that none of Santa's little helpers were harmed or mistreated in any way in the making of this podcast. Take care, everyone. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.